Welcome to the first of 5 installments in the webinar series titled Enhancing the Value of Growing Private Equity Platform Companies via Proactive Compliance Initiatives. Today's program will address and provide guidance on immediate post-closing operational fixes. Joining us are 4 Epstein Becker Green attorneys. John Eriksen is a member of the firm in the healthcare and life sciences practice. He regularly counsels clients on a wide range of issues, including strategic development, transactions, interactions with state and federal agencies, and routine and non-routine contracting matters. Josh Freemire is also a member of the firm in the healthcare and life sciences practice. His experience includes work with private equity companies and other healthcare investors and their portfolio companies on a broad spectrum of health regulatory concerns, including fraud and abuse, privacy law, licensing, reimbursement, multi-jurisdictional practice, and entity structuring, compliance, and disclosures. Gary Herschman is also a member of the firm in the healthcare and life sciences practice. He advises and assists providers in strategically positioning themselves in a rapidly changing healthcare marketplace. This includes counseling clients in regard to consolidations, affiliations, mergers and acquisitions, as well as joint ventures, decision alignment, clinically integrated networks, ACOs, MSOs, IPAs, PHOs, and population health contracts. Marc Mandelman is a member of the firm in the employment, labor, and workforce management practice. He represents a variety of clients, including major corporations in the financial, insurance, fashion, retail, publishing, technology, and healthcare fields, in all aspects of labor and employment relations. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenters during and after the webinar. Their contact information will be displayed again at the end of the presentation. In 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of today's program and PowerPoint materials. At this time, I'd like to turn the presentation over to Gary.
Thank you very much, and thanks for everyone for joining this webinar. We are going to address 5 categories of proactive compliance initiatives for post-closing fixes on compliance issues post-acquisition. The 5 topics we're going to cover are establishing appropriate policies and procedures to ensure ongoing compliance with corporate practice of medicine and other regulatory restrictions. Number 2, creating effective processes around consolidation efforts, including reductions in force and management changes. Number 3, building out revenue cycle functions to proactively address billing and coding errors. Number 4, terminating problematic arrangements, if any, for financial or compliance reasons. And finally, if needed, executing possible self-disclosures and other remedial actions. So Josh is now going to talk to us about establishing policies and procedures.
Thanks, Gary. So when I have looked at these types of companies, both in a diligence capacity and later on working with portfolio companies, one of the things that jumps out pretty immediately is that those companies need to do a better job of understanding how state laws impact their business structures. People are pretty familiar with the federal laws, federal fraud and abuse laws, federal Medicare enrollment, things like that. But state laws impact different provider types very differently, depending on the type of provider that we're talking about. State boards and licensing issues come up pretty frequently. The state-to-state regulations in terms of corporate practice of medicine, state fraud and abuse laws, fee splitting, self-referral, kickback issues, those all can influence how you're organized within a state, whether you use an in-state or out-of-state entity and foreign qualify. They can also impact how you structure your employment relationships. You also want to look to the scope of practice issues, supervision issues. Those can vary from state to state and provider to provider. Drug dispensing, controlled substances registration, and board approval. Depending on your structures, you may need board approval for fictitious names and related issues. Corporate practice of medicine concerns can impact how management fees are paid in a friendly PC structure, how ancillary services are provided, and even how employment agreements are structured, whether or not you can have non-competition agreements, for instance, or non-competition provisions. So all of these go into determining whether or not you use an entity that's domestic to a state or maybe foreign qualify a different entity, whether you have multiple entities that practice across several jurisdictions apiece, or whether you use one per state. In terms of figuring out your policies and your structures, that's kind of a first step, and it plays into the diligence issues, which we also recommend you address at closing or as soon as possible thereafter. People kind of overlook diligence issues, and they're done as part of the initial look at the company, but usually not followed up on, or often not followed up on. The government has been noticing that in terms of investors, so that's an issue that we recommend people look to immediately. Corporate practice and medicine structures that are identified as needing fixing should be fixed at or near closing if possible. Frequently, docs in friendly PC arrangements or other entities are going to be a lot more amenable to changes to their contracting if that's handled as part of a larger transaction rather than waiting further on down the road. Frequently, they'll try and leverage that either into an increase in compensation or to other changes to the structure. So that's something that you want to look at, preferably prior to closing, but if not prior to closing or at closing, then soon thereafter. And finally, you want to work with the practice, especially in a friendly PC structure. You're going to want to work with your practices to develop budgets and strategic plans. Working with them will allow you to get practice buy-in, sort of the plan and the strategy for the company going forward. You'll avoid the titular ownership accusation. Gary will talk about that in a moment here. And working directly with the practice and sort of setting that up as a process creates a process that allows continuity regardless of the individuals that are involved. So there's a process and a structure that determines how the company moves forward, how budgets are set, how decisions are made, and that's something that can carry forward even if there needs to be a change in personnel. Finally, having that conversation with management early and somewhat aggressively in terms of early post-closing allows you to identify any differences between the goals of the management company, the greater business entity, and any individual practice owners. You can identify those and make changes as need be, including changes to the personnel if need be, rapidly post-closing. And Gary, you wanted to speak a little bit about friendly PC structures?
Sure. So there has been some enforcement of state attorney generals and medical boards on friendly or captive PC structures, and they've also been challenged by insurance companies. In fact, in the New Jersey Allstate Supreme Court case called Allstate from a couple of years ago, it called into question the bona fideness of a captive PC, claiming there was just merely titular ownership and that it wasn't done in a bona fide way. There's been enforcement, in New York State. There's been starting to be rumors of enforcement in many other states. They're starting to wake up in light of the growth of investor arrangements with physician groups. So our recommendations are to keep the cap in the states, which is most states, where you need to have, where there's corporate practice of medicine and you need to have a friendly or captive PC. We recommend 10 categories of actions to proactively address these things. And all of these are relatively easy to do. I'm going to go through the 10. Number one, maintain medical malpractice insurance covering the clinical oversight duties, and name the practice. Make sure the practice is a name insured on malpractice policies. Number two, and this I think is the most important, is to have the physician owner attend regular board meetings and monthly or quarterly on-site meetings with the employed physicians and professional staff. Each of those meetings should have detailed agendas and minutes. And at those meetings, at least 4 times a year, preferably more, there should be on-site presence of this physician owner and reviewing of various data about the practice and discussing improvements with the physicians and clinical staff. Number 3, the physician should sign off, like sign a little one-page document signing off and approving the hiring of each physician and other clinical staff following a review of their attached credentials. And preferably, they should conduct a final interview with physician candidates. So again, the management company, the platform, can put together the credentialing material. There should be a page on top that the doctor has reviewed the credentials and maybe also notes about an interview they had with the doctor and approve the hiring. I think that's very important too. Number 4, the friendly doctor should review and sign off on an annual basis on all of the practice's medical and clinical policies and procedures for medical equipment, policies on record keeping and confidentiality, policies on controlled dangerous substance storage and security, marketing and advertising campaigns, billing policies and procedures, list of current fees, and all those categories. Any amendments, the platform company should not just unilaterally implement. They should propose the amendment and have the doctor sign off on them. Again, it shows more bona fide involvement of the doctor in clinical and other aspects of the practice that are important to demonstrate bona fideness. Sign all contracts for professional services. So if there's independent contractor agreements, they should sign those too. They should sign physician employment agreements, professional service agreements, if they have a professional service agreement to provide call coverage at a hospital or other medical facility. And they should sign off on all payer and managed care agreements, IPA, clinically integrated networks, PHOs, and agreements with all payers. Even though the platform management company will be actively involved in assisting in all of those efforts and negotiating, the final sign-off should be by the doctor, the friendly doctor. The doctor should also review quarterly compliance audits. And again, these audits could be conducted by a third party or by the management company, but they should cover coding and billing, quality of care of each physician, and documentation practices of each physician. And then, item 8, the friendly doctor should oversee any corrective actions based on those audits, including directly communicating with relevant physicians to improve their conduct if there's a problem with the physician. Number 9, we recommend that the practice pay some base compensation to the physician owner and project some year-end profits remaining in the physician practice rather than wiping it all out to zero, to have some profits that are actually distributed, in a corporate or LLC distribution manner. It doesn't have to be a lot, but it counters the bare legal title argument that others would make on the opposing side. And then finally, the management contract between the platform management company and the medical practice should be consistent with all this. It should reference all these rights that the practice and the friendly physician retains. I recommend avoiding lengthy, 30-year contract terms, and it's very important to also have a right of the practice to terminate for cause. Only on material breaches after a cure period, but they've got to have a right. The contract can't be forever if there's breaches. So with that said, I'm going to turn it over to John to discuss key compliance issues in connection with post-closing consolidation efforts.
Thank you, Gary. Yeah, just tick through a few issues with regard to consolidation of platform functions across in a post-close environment. One consideration, bullet 1, is ensuring the ownership and alignment of incentives agrees as you're trying to consolidate various platform functions, such as back office or revenue cycle functions. If you're consolidating multiple platforms, some of the previous existing platforms will be going away in that regard, and you'll have to make sure all the prior owners get put up to speed in the management company. Another consideration along that is an expansion consideration in the establishment of certain clinical functions, such as a centralized lab or imaging functions or ASCs, needing to do that ownership correctly to be cognizant of the Stark and anti-kickback rules as to those ownership of those clinical functions. The second area is to review and understand your vendor agreements and create a plan really around what ones you want to keep, what ones that should be going away, and to map out all of the considerations from an operational perspective of how long the transition and the costs in that regard are going to be. Also important when you're thinking about terminating agreements to understand what the termination requirements are, what the time periods are, and what potential penalties in terms of any of those terminations are. At some point, there will be likely some discussion around a buy versus build on certain functions. There's an economies of scale point that any platform realizes to decide whether they, for example, they want to intake a function as opposed to having a vendor. Early on, it probably is easier in a lot of instances to have vendors perform things like revenue cycle, but it's also really important to be cognizant in that environment that you can't outsource compliance for your entity, and if a vendor messes it up without and you fail to oversee them and be cognizant of their activities, it's not the vendor's fault ultimately. It comes back to the platform. In terms of creating a process around consolidation, it's advisable to do an assessment, do a gap analysis about what you have, what you should be getting, and of course try to reduce redundancy. There's a tendency in the rush to want to make things better, to potentially bite off more than you can chew, and it's important in that regard to map out a good plan and budget so that you get things done in a timely manner, but at the same time don't overwhelm the operations folks who will likely already be overwhelmed and create potentially a further slowdown in operations post-close. There tends to be, as onboarding occurs, a revenue dip in the immediate post-close period, and so we would not want to add to that. And then, of course, as you're creating all of this centralized function and integration, it's important to have your practice leadership and your managerial leadership to be bought on the centralized function across the board. And now I'll just turn it over to Marc, who will go into some of the staffing considerations.
Yes, thank you, John. So when planning a reduction in force, there are many decision points and potential risks and pitfalls that need to be considered. So it's important to work with knowledgeable legal and HR advisors to guide you. Overall, the main thing is you don't want to get sued by terminated employees individually or as a class, or have regulator enforcement actions result. Without proper planning, you can easily walk into discrimination claims, whistleblower and other retaliation claims, breach of contract claims, or WARN Act claims. Planning a RIF begins with and should always be guided by the business objectives to be achieved, and that should be clearly established and documented up front. You want to establish and document the non-discriminatory selection criteria for each impacted position and the business rationale that supports and is consistent with achieving the business objectives. Next, it's important to identify and plan for compliance with any individual contractual terms or separation compensation obligations. These can be found in informal employment contracts and offer letters or other post-hire commitments such as retention awards. Hopefully, these obligations have been identified in the diligence process, but they need to be complied with. To mitigate and manage the risk of terminating employees, we generally will want to ensure that each terminated employee signs a valid and enforceable release of claims. Unless already provided for in a contractual obligation, this will generally require the offer of additional consideration for the release and usually some amount of severance pay and or benefits in exchange for the release. There are a number of federal and state technical requirements that must be complied with in order to obtain an enforceable release of claims. The most significant requirements are driven by the Federal Age Discrimination and Employment Act and its amendments, which apply to age waivers for employees who are over age 40 or over. In a group termination scenario, meaning the termination of more than one person, the Age Discrimination Employment Law requires that the release agreement offer at least 45 days to consider the release, a 7-day period to revoke the agreement after signing, and most significantly, the provision to each employee who's age 40 or over of a listing of all job titles and ages of those selected and not selected for termination. The preparation of that disclosure information can be extremely complicated and a fraught process. And strict compliance is necessary to ensure that you obtain valid age discrimination releases. Finally, when undertaking a RIF, it's essential to evaluate whether federal or state WARN Act advance notification laws are implicated. You must monitor and track the numbers of terminations at each work site, generally over a rolling 90-day period, including accounting for terminations that occurred prior to the closing of an acquisition, as seller terminations can combine with buyer-initiated post-closing terminations to trigger WARN Act advance notification requirements if those combined terminations span the 90-day period. There are various ways that WARN can be triggered, but in some, if you're planning on terminating 50 or more employees within a 90-day period, you need to closely analyze whether a WARN is implicated. The failure to comply with the applicable advance notification requirements can create liability to each terminated employee for the cash value of all pay and benefits that would have been earned or accrued for up to a 60-day period, plus civil penalties and attorney's fees. The cost of 2 additional months of pay and benefits to each terminated employee, on top of any severance pay that may be offered, can be very costly. And this liability can only be satisfied on an unconditional basis, meaning it cannot be conditioned on the signing of a release of claims, and can only be offset against offered severance pay with very careful and skillful advance planning. There has been much litigation attempting to hold private equity firms liable for portfolio companies' WARN liability. Thus, it's very important to observe and adhere to corporate formalities and the separation between private equity firm personnel and the portfolio company's board and management in respect to decision-making and implementation of a RIF. So now I'm going to turn it over to Josh Freemire, who will discuss right-sized compliance structures.
Thanks, Mark. And it helps to kind of define what we mean by right-sized compliance structures. So as the company grows, they're going to be on the hook for more and better sophisticated compliance structures. When the government takes a look at companies, they take into account their size and projected sophistication, especially PE-backed companies where they're going through kind of bolt-on, tuck-in type acquisitions. They can grow in size rapidly. So you want to pay attention to that and make sure that you continue to stay on top of growing the compliance program. The first place to start there is identifying who's going to be responsible for it. Frequently, we get asked about whether or not you can have a compliance officer, general counsel, dual role. There's a whole conversation to be had about that, which I'm happy to have with folks, but that ultimately, that is disfavored by the government. It's not something that we recommend. But we do recommend that there be one, at most 2 people who are ultimately responsible for managing the implementation, creating and managing the implementation of the compliance program. They should work with trusted advisors, both outside counsel, inside counsel, and outside consultants that have familiarity with the business, preferably ones that have been engaged through counsel so as to maintain privilege. The management company in a friendly PC type structure is going to develop the compliance program. You can't rely on your friendly PCs to do that. They just don't have the resources. It has to be reviewed and adopted by the practice, though, and ultimately it's going to be the practice that's going to be responsible for implementation and oversight, because those professional matters need to be overseen by the professionals, preferably the owner, but he can have a designee in terms of a medical director or something similar at a practice. Implementation of the structure that's developed is key. A desk drawer compliance plan doesn't do anybody any good. It's ultimately maybe even a little worse to have a plan that says you're going to do X, Y, and Z, and then discover that you haven't done any of those things, and that failure led to an issue. There's lots of guidance out there from the OIG and other folks, as well as from us, in terms of the best way to structure compliance programs, how to scale those to meet your needs. Again, that's something you want to work with compliance professionals and inside and outside counsel to develop. Once you have structures, it's going to be key to train employees. This is a frustrating and time-consuming step. So often it's overlooked or given a little bit of short shrift in the desire to grow as quickly as possible. But candidly, if your employees aren't told things, you should assume that they don't know them. So if you're assuming that the professionals understand how to handle their billing and coding responsibilities, understand how to properly document, you're probably giving them more credit than each of them necessarily deserves. There will always be someone who isn't doing what they ought to be doing. Part of doing the training is so that the company as a whole has an ability to say, we told him not to do that. That person was trained not to do it that way. You want to document all of these structures, and when someone asks you to see your compliance plan, which the government may do, you want to have a document that you can hand them that is updated, that is understood, that has been implemented and trained across the enterprise. You want to keep that constantly updated to reflect developments in risk areas for your particular industry, as well as changes in the company structure, whether it be new divisions, whether it be significant expansion, changes in the computer system. You want to make sure those are reflected in your most current compliance materials so that when it is asked for, you have something polished that you can hand over. Finally, you want to check your work and you want to monitor your employees, and that's going to mean quizzes, it's going to mean secret shoppers, it's going to mean audits, and John's going to talk a little bit more about audits.
Thanks, Josh. Important to any revenue cycle operation is the audit function, and as any platform grows and becomes more integrated and you're standing up a compliance program, you have the revenue cycle audit function coupled with the compliance audit function working hand in hand to improve the organization's billing and coding functions. The goal being to, of course, bill and code your services accurately and to mitigate any risks of overpayment issues or potential investigation by government agencies or plans of inappropriate billing practices. Any audit function will begin with identifying the risk, create a plan, execute the plan in terms of periodic, quarterly, monthly audits of key areas of concern, and this also general. Any area of concern that is raised up to the organization should be the subject of a target audit. And then when you go in and choose your sample and audit the claims and review the medical records, determinations of outliers in that regard from a provider perspective or a services perspective need to be the subject of remediation and, if appropriate, potential repayment of funds to the government or payer.
And just to chime in briefly on John, just to add to that, you want to involve outside counsel as necessary in this process. So to the extent you identify an issue that you think may result in repayment or that may carry with it some kind of compliance liability, you're going to want to roll in outside counsel, make sure that the further review and the deeper look into those things are privileged and that that's handled appropriately.
No, absolutely. That's an appropriate comment. And one of the things that occurs when using external auditors, coding and billing auditors on occasion, or not on occasion, quite frequently really, is that they will come back with a series of recommendations that at that point become obligations because now you've had an external entity review your work. And to the extent that those people are not engaged by counsel, whether it be the general counsel of the platform or external counsel, that material is now not privileged, and the process of deciding what the remediation should be becomes more difficult. One last point on the coding audits. It does sound like a burden, but getting it right is important. And getting it right also, in my experience with any coding audit, is not just a downside, it's also an upside. It's quite frequently that the coding is coded incorrectly, both positively and negatively. So with that, I'll turn over a little bit more to process. Billing, there should be a known plan around billing and coding audits. And again, the results of that should be communicated to management on a periodic basis as those audits flow through the company. Certainly any issues should be communicated immediately, but generally the process should be communicated periodically. And remediation actions that have been identified should be also communicated, and the results of those through the governance organization.
An integration of the compliance function is a key part of this that we're talking about. And a little too often we see compliance cultures that develop where the compliance department is a little siloed, and they tend to think of themselves in a gotcha role or even as an internal whistleblower role. They're really there to facilitate the company and ensuring that the company is doing what it needs to be doing in terms of compliance. They are on the same team, and that's a cultural issue that you want to impress on folks, and the immediate result of that is hopefully avoiding what we call bad paper, and the kind of emails that say the initial sampling, this sample's really bad, guys, this is terrible, this might be fraud. You don't want to say fraud or repayment in emails. That can trigger obligations that you wouldn't otherwise have. The email and the reporting structure should be organized in a fashion that supports the company's mission, identifies potential issues for correction, but otherwise is calm and straightforward about the results of the audits. And John, did you want to talk any further on slide 11 before we move on to Gary's?
No, I think we can proceed.
Okay.
Great. So I just want to remind all of the attendees that they could start, if they have any questions, they can start plugging them in at the bottom. We're going to get to Q&A in about 5 minutes. So on slide 12, what we're talking about here is terminating problematic arrangements that are discovered in due diligence. And these are not, there's a lot of compliance issues that are relating to coding and billing or appropriate licensure. What we're getting at here is different. They're problematic financial arrangements that pose issues of compliance, and if there's a referral arrangement in particular. So we're really talking about physicians who are treating patients and arrangements with them or payments to them, physicians who are serving as medical directors, and potentially vendor arrangements that involve marketing or any direct or indirect referral streams. So it's important that any of these arrangements be in writing, be bona fide services that are really needed, be fair market value, if there's payments, fair market value and on commercially reasonable terms, and not be based on the volume of referrals, any type of compensation. So when there's issues like this, it's very important to involve, again, like you heard a few minutes ago, to involve legal counsel, because otherwise discussions amongst company executives is not privileged. So it's very important for this type of review and these types of discussions to be at the direction of inside or preferably outside legal counsel. And so where a problem exists, and by the way, there's a reference here to 1099 and AP runs. We think it's very important. I think this is the best piece of advice I can provide anyone. But and this is usually done in diligence, but the issue here is correcting post diligence. But if you do an annual 1099 run on the target, an accounts payable run on the target, you might be able to identify payments that are made that don't connect up with an agreement. And those are ones where you don't have anything to review and could pose, an issue that there's not even an agreement, and some regulatory requirements like Stark require some type of writing or collection of writings. So right after closing, if these arrangements that were identified, problematic arrangements, were not terminated as a condition of closing or self-disclosed or otherwise dealt with prior to closing, it's very important immediately after closing to address them, to either do a modification via a short one-page amendment, or if it can't be amended or it's so problematic, to assess termination rights and to terminate the contracts. And it's also important to look at your existing compliance policies and revise them as necessary. So if there's a hole in terms of physician contracting and there's not very strong compliance policies around physician contracting and, sign-offs by legal and compliance departments and fair market value reviews, very important to amend those policies on those issues right away, and then to train your staff on those policies and make sure you implement them, which means 6 months later, re-audit and make sure that things haven't slipped back through the cracks and that these types of problematic arrangements are not, being entered into on a going forward basis. So Josh is now going to talk briefly a little bit more about remediation initiatives.
Yeah, and really talking here about disclosures, potential termination issues. These are things that honestly we could do a whole separate webinar on, and folks have done one, and I'm sure that we're going to talk about these more as this series goes on. But for purposes of this, immediately post-closing, to the extent something is identified. And Gary mentioned 1099 and AP runs. I mean, those are something that may be skipped over in the course of a very large transaction, but turned to post-closing on an individual entity basis. You may look to greater details than that, and you may come across something that, a particular practice in this geographic region has payments that we can't account for. What do we do? And the short answer is there are a lot of self-disclosure and repayments options out there. Which you choose and how exactly you sort of go about it is going to be very fact-specific. So I'd love to give a bright line rule or a set of bullets on exactly how to handle those. But whether you go to the OIG, CMS, DOJ, whether you just repay to the carrier, whether you reach out to private insurers, all of this is going to be very, very fact-specific. And so a key part is just gathering the facts. That's going to be the first thing that you're going to do. And you want to identify early on in a situation like this. It's similar to when John was speaking about identifying issues in an audit. To the extent that you identify an issue that may result in a repayment here, you want to reach out to your trusted advisor, outside counsel. You want to get them involved to oversee the investigation, which is literally just a gathering of information. They'll work with a limited group of inside counsel, compliance personnel, some management, but you want to keep that group small to ensure continued privilege. You'll gather the information that's necessary and decide based on that what you think the best way is to correct the issues that have been identified. No matter what happens as a result of that investigation, whether repayment is necessary or disclosure is necessary, you're going to want to figure out how the issue arose in the first place, patch the hole in your policies and procedures, as Gary just mentioned, and then go back and re-educate the providers that are involved. And it may mean terminating some providers who have real significant issues or played a significant role in creating the compliance failure. But in most circumstances, education is going to address the issue. And looking at how things operate, potentially from an electronic point of view, whether it's electronic medical records, whether it's how the billing and coding software works, but really sort of going to a source of the issue and eradicating that going forward. And I think that we are about out of time. I'd like to turn it back over to the moderators, and we can do a little bit of Q&A here for 5 minutes or so before we're done.
So I appreciate that. Thank you. So if there are some questions that have come in, if anybody has additional questions, now would be the time to type them in that box on your screen. The first question here is, it says there are dozens and dozens of physician investment by private equity and other companies. Explain the need to comply with CPOM rules. So I think I'm gonna let Josh comment on that, but I'll just say that during my presentation, I did reference that, there's starting to be greater enforcement, of corporate practice issues. And, our advice to all of our clients, even clients that have had, investments in platforms for several years now, to really go back and try to beef up the bona fideness of these friendly physician arrangements, because there have been recent developments that, show an increasing trend of enforcement. Josh or John, did you have anything to add to that?
Yeah, I think in answer to the question, explaining the need, each state has to be looked at individually when you're making corporate practice of medicine or CPOM assessments. You need to make a decision about whether this particular state has, what are the rules there, how does it work, and you need to make sure that the structures that are used, friendly PC or captive PC, depending on how you characterize it, your management agreements, the payments that are exchanged between the personnel, whether or not you have a shared transfer agreement, whether or not you have employment agreements, and how those are structured between the management company and the practice and the professionals. All of those issues come into play. I'm not aware of a single state where it's impossible for a private equity company to invest in professional entities like a physician practice. I've worked on those across the country. But each state is different, and it's important to be aware of the rules in a particular state and ensure that your structures comply in each individual state. What I do see a little too often is folks who get one model, then they grow and roll it out on a rapid basis, and what works great in Virginia may not work in Texas, may not work in Illinois, may not work in New York. So that's kind of our focus and our advice.
Right, and interestingly, everyone's familiar with the False Claims Act, and it's interesting how 90+% of False Claims Act enforcement nowadays is by these qui tam plaintiffs, these people that worked at a company, are bringing these False Claims Act cases. What's interesting in corporate practice of medicine is it's the payers. There's been, the New Jersey Supreme Court case was about an automobile carrier that challenged payment to a particular physician practice. And that went all the way up to the Supreme Court. I believe in some of the New York State enforcement initiatives, and there have been some settlements there that a lot of, the Attorney General was kind of prodded by payers to enforce. So payers are the ones that are out there kind of stirring things up, either directly or through, complaints to state AGs. So I do think that, usually these things, once they start, other payers catch on to the playbooks of other players in the competitive marketplace. So I do think it's smart to make sure your house is in order and to initiate amendments if needed to have a more solid footing. And again, as Josh said, it is state by state. There's another question here about medical directorships and how they pose issues. So medical directorships, John, do you want to address this one? Medical directorships. There's a lot of companies, whether they're regardless in the healthcare industry, have medical directors. Do you want to address that issue? Is how that poses compliance issues?
Yeah, if you could read the question to me in a minute. I just wanted to couple up with some of the response from the last question. Is that certainly while it's a new field of payers wanting to seek enforcement around corporate practice structure and the legitimacy of it, one of the other very large buckets, and it's something to be very cognizant of, both in terms of over-promising compensation at the outset, but also keeping track of the satisfaction level of your providers, disgruntled providers from inside of the organization are another very, very common source of corporate practice complaints. With that said, I'm happy to answer the medical director if you could read it for me.
Yeah, it says how can medical director agreements pose compliance issues in companies?
Medical directorship agreements, as you know, both in this context and in any other healthcare context, assuming it's with an outside referral source, would have to be properly documented, both in terms of having an appropriate contract, an appropriate FMV, as well as tracking of the time and toggling that back against the contract terms before payment goes out. In terms of medical directorships of persons within the organization, you could have certainly separate medical directorship agreements on top of their employment agreements to provide functions to the organization. Again, those have less scrutiny on them, but they should be tracked appropriately and not put the compensation for that particular individual way outside of fair market value assessment for that person's function in the organization. It's also important with any organization to have an assessment of a legitimate number and a legitimate functionality around the medical directorship. So if you saw an organization where you had 25 physicians in it and 22 medical directorships, there's likely something a little bit off going on there.
Right, and I also note that usually in certain companies, like a dialysis company or an imaging company, it's very common for the person selected as a medical director to be one of the highest volume referral sources, of the center. So that, I think, is just another example of why that could be a compliance issue. Is it just a subterfuge to pay them money indirectly for referrals, or are you really paying, like you said, John, the fair market value for bona fide services and preferably services that are logged each month to show the number of hours for bona fide services? So with that being said,
and that just to add to that, that goes both ways. It's both entities that the organization might hire, or people that the organization might hire, but it's also other external entities such as a home health agency, for example, who might hire one of your staff to be their medical directorship. It works both ways. You can be both the giver and the recipient of a kickback, and you don't want to be on either side of that equation.
Okay. David?
This concludes today's webinar. Reminder that in 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of the presentation and PowerPoint materials. We hope you'll join us for the next installment of this series, which is scheduled for next Tuesday, October 9th at 12 p.m. Eastern Standard Time. Presenters will discuss different approaches to establish a cost-effective assessment of smaller add-on or tuck-in targets. For more information and to register, please visit www.ebglaw.com/events. Thank you for attending.